Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in the Bureau of Immigration's San Diego office. And as always, I'm here today with Miki Matrician, who is the co-managing partner of our Boston office. How are you doing today, Miki?
Hi, Kim. Doing well.
Awesome. All right. Well, for today's installment of Rapid Fire Wednesday, we're going to talk about how companies might change their green card sponsorship programs and policies based on a Trump 2.0 administration. We had some interesting discussions with members of our benchmarking collective that we thought we would share. So, our Immigration Benchmarking Collective is a global mobility community that we started about 7 months or so ago. We now have over 300 members, and our collective is really unique. It's unique because the information that we obtain is directly from global mobility professionals who are in the trenches, so to speak, as opposed to third party individuals. And so, based on the results from these surveys, we provide personalized benchmarking reports tailored to an individual company so that you can see where your program falls with other programs. So we have also been hosting roundtables that have been built off of these surveys. And Mickey, do you want to tell us a little bit about these roundtables?
Yeah, sure. We've hosted several virtual and in person roundtables, and we facilitate the discussions based on the topics that HR and global mobility professionals want to hear about so they can really just exchange ideas and their experiences. And the conversation's been really robust. It really flows, and we've been getting some great feedback that these discussions have been helpful to people. I just love that people are exchanging ideas and kind of the light bulb goes in their heads. They get to expand their networks too and forge relationships, which is an additional benefit. I love being part of these discussions and really learning from them as well about what is the challenge that they're facing given particular green job cases or other non-immigrant type cases. And I think that this is a fantastic community.
Yeah, it has been fun, being part of the roundtables, just listening to the ideas that people are able to share and have a really great discussion. So it's been wonderful. And the surveys have been, interesting and fun as well. We try to pick some really relevant topics that sometimes are based on pain points that professionals have within the immigration space. So, one of the questions that we asked the HR and global mobility professionals was about the tenure requirements to initiate the green card process for foreign national employees. So, Mickey, what did we learn from our benchmarking collective when we asked them, how long do you wait before you might start the green card process?
Yeah. So we saw that 37% of survey respondents said their company initiates the green card process on a case by case basis. 24% said that they initiate after 12 months of employment. 13% said they initiate after 6 months, and then 13% immediately. So we did see a difference between smaller and larger organizations, with larger organizations tending to start processes sooner rather than later. And it also was important to note that 67% of respondents provided that their company does, in fact, consider employee performance before they initiate the case.
Yeah. So, Mickey, one of the concerns that, the global mobility professionals had expressed during the roundtables was increased cost, with the green card process and more likely during a Trump 2.0 administration. So, when the green card process is typically started with the PERM labor certification application, an employee cannot pay for any of the fees or costs associated with that part of the process. So, what have you been talking with your clients about or has been mentioned in the roundtable of how global mobility professionals might be able to change their programs or policies or try to contain those costs of the whole green card process?
Yeah. So the discussion seems to have been around premium processing. 75% of respondents said that their company does cover premium processing costs for I-140 immigrant worker petitions. And with more and more concerns about cost containment, clients have been considering changing sponsorship policy by not paying for premium processing or only paying for premium processing when there's a business reason to do that, such as when an approved I-140 is needed to get an extension of the H-1B. With USCIS premium processing fee having gone up to $2,805 and from 15 calendar days to 15 business days, it's been a pain point. The costs really add up fast. So there are other ways to contain costs too through cost shifting model.
Right. So we also talked about in the roundtable, the repayment plans or policies, right? Of having a company say to the foreign national employee, we'll sponsor you for the green card process, but we're going to claw back essentially or ask for repayment if we get to a certain stage in the green card process and you might leave employment, right? So in the survey, we noticed what was reported was that 63% of the respondents said that they don't have a repayment plan or policy, which is interesting, right? I know I work with a bunch of clients who do have a repayment process, but just talking about it in the roundtable and with companies talking about what's going to happen, under a Trump 2.0, which may or may not impact this, but what do you see with respect to, the repayment plans or processes?
Yeah, yeah. I guess before we dive into it, one of the things that I think is really worth highlighting is that while companies can seek repayment for parts of the green card process, by law, an employer cannot have an employee pay for any of the fees or costs associated with the perm labor certification application. And that's typically the default first step of the green card process. It is permitted to have repayment agreements or clawback agreements that you mentioned for I-140 petitions and I-485 applications, but I just want to make crystal clear that perm labor certification cannot be part of that scheme. During our discussions with HR and global mobility professionals, they've expressed one of the pain points is the likely increase in immigration costs given the results of the presidential elections. People are anticipating increased scrutiny in USCIS adjudications, which means that there will probably be an uptick in RFE rates. And when talking about strategies with clients, there's been discussion about cost control as well as balancing that with trying to reduce stress and anxiety of foreign national employees with the expectation that the green card process will not only take more time, but will become more burdensome. So given those concerns, we may see more companies allowing their foreign national employees to cover the costs of self pay for premium processing costs as well.
Right. Our prior survey with the green card process and policies, Mickey, showed that 74% of the respondents said that their companies will sponsor and have sponsored multiple green card pathways for foreign national employees. You were just talking a little bit about, containing costs as well as what companies might be doing with respect to repayment policies or clawback provisions. And as you mentioned, companies can't claw back anything with respect to the perm labor certification application, but they can with the I-140 petition or the adjustment of status application. But how do you see the sponsorship of multiple green card pathways potentially playing out in the future?
When I work with my clients, we're often reviewing the various strategies and pathways when an individual might have more than one way of qualifying for green card status. And in some situations, that might be that the perm process and also an EB1 process might work, like an outstanding researcher or extraordinary ability, or sometimes the EB2 national interest waiver, if the individual has the right qualifications and the role is it qualifies as well. And so it may mean that the individual will work on a strategy to obtain the necessary qualifications over time to become eligible in the near future for EB1 or national interest waiver too. So, what we've heard from the benchmarking collective is that many companies may support multiple pathways, but that may not necessarily include financial support of a second process. Again, because the employer doesn't need to pay for the I-140 or the 485, it may mean that, companies are sponsoring signatory on I-140s for EB1 or national interest waiver, but maybe the foreign nationals self-paying for those processes. There are also situations in which a foreign national is promoted over the course of their career with a company and a new perm process is initiated, which might mean that going from EB2 to EB3 is sort of an upgrade.
Right. So those are really important points and some things for, global mobility professionals to think about in terms of potentially, revising their policies or just kind of give it a little bit of time to see how things play out in 2025. So that's a wrap for today's Rapid Fire Wednesday session. And we're excited to see everybody again when we meet up with Rapid Fire Wednesday, and we will be taking a little bit of a break during the holiday season. So until then, please follow WR Immigration on LinkedIn, and you can also follow Mickey and me with our individual profiles on LinkedIn. We also transcribe our Rapid Fire Wednesday into a newsletter that we send around every week, and you can always subscribe to that in the comments. So thanks so much, and great to see you again, Mickey.
Good to see you, Kim.